Oops, I did it again. I did it again. There we go. Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. We're coming at you again tonight with the second part of the Federal Reserve Circular number 1. The loop-de-loops. And we're going to go on with the next section tonight. Remember, folks, the StreamYard link is down there for anybody that wants to join the panel. So please feel free to hit that and come on up. And we are going to get into it with the next part, 3.0. We finished up with 2.12, maintenance of agreements and other records. As an account holder, you must maintain all master account agreements and all other reserve bank account agreements continuously as official records of the financial institution. For 3.0, we're talking about settlement. And it says an account holder's master account. So now we see, as I spoke before, you have the respondent that has a master account, which is a administrative reserve bank, and then the correspondent has a master account, and the correspondent is an account holder. The administrative reserve bank is an account holder, and they get their account holdings from the Federal Reserve Bank, split up into the various different districts of the Federal Reserve System. When you have an identification for a commercial identification to transact such debit and credit transaction activity, then you are part of that Federal Reserve System. You are presumed to be a Federal Reserve agent, allowed to transfer Federal Reserve notes as advances from one Federal Reserve institution to another. And for no other purpose are they allowed. That's the presumption, folks. An account holder's master account is used to settle debit and credit transaction activity arising from transactions that the account holder conducts with or through any reserve bank. An account holder may serve as a correspondent to a respondent as provided for in section 2.7. The transaction and service fee settlement authorization form must be used to designate any separate settlement arrangements for particular payment services. Particular being specified. In other words, the private payment services. A respondent that maintains its balance maintained to satisfy the reserve balance requirement. Remember, I said this isn't a national currency, that's a reserve currency. As defined in Regulation D with a correspondent pass-through. With a correspondent in a pass-through relationship. See, like I said before, it's not supposed to be a checking or savings account where you hold things, because then you become a holder. You use it as a pass-through. But desires to settle directly. There's that term directly again for directions and directives. You're supposed to act as the director, giving directions. For some or all reserve bank services, may, with the approval of its ARB, open its own master account for that purpose. Settle directly for that purpose, for direct settlement. It's plain writing, folks. They're telling you how to do it. It's called negotiable instruments once again. You have to learn how to negotiate. The respondent remains responsible for settling its debit and credit transaction activity. If settlement through the master account of its correspondent fails for any reason, where a respondent directs settlement of debit and credit transaction activity to a correspondent's master account, a reserve bank's credit to the correspondent's master account or to another account designated by the correspondent constitutes final settlement to the respondent. Where a respondent directs settlement of debit and credit transaction activity to a correspondent's master account, a reserve bank's credit to the correspondent's master account or to another account designated by the correspondent constitutes final settlement to the respondent. They're telling you how to give the directive. They're telling you how to give the directive. Greetings, Norman Longstaff. Norman Longstaff is up there, one of them Canucks, and he's doing a great job. Says, happy Wednesday, Keith. 96 is the fix worldwide. Bills of Exchange Act. Look on the bottom of your billing statement, folks, no matter what kind of bill it is. There's going to be a detachment that they ask you to detach and send in with your payment. On that detachment, if you see a 96, it's telling you that it's already prepaid. And all you have to do is give them said directive according to your nation's laws. That's why we use the same like wording to give that directive. So thank you, Norman Longstaff. So we're going to continue on. It says, a reserve bank may also debit or credit a master account as provided by regulation, operating circular, agreement, or applicable law. So they can go and do some forum shopping. They can use the forum provided by regulation, by their operating circulars, by other agreements, or as applicable already in law. Already applicable law. It means it's already there and all you have to do is apply it. It's called equity, folks. Statements and accounting information services. Statement of account. An ARB, Administrative Reserve Bank, provides a daily statement of account to each account holder. The account holder is responsible for verifying the information on each daily statement of account and must promptly notify its ARB of any error in its statement of account. Does anybody get a statement of account daily from your bank? If an account holder fails to provide written notice to its ARB of an error in its statement of account within 30 calendar days of the date of the entry, it is deemed to have approved the entry. This is the error I've always been talking about, an error in entry. It's an error in the entry. Had I known de novo back in the beginning, had I known de novo, I would not have done that. I am conscientious of how this works now, and so I can no longer do that. A reserve bank will investigate any notice of error and determine whether an error actually occurred. Remember what I said about last night, 12 U.S.C. 611 through 614. That's your qualifying structure for it to be applicable, applicable law, regulation, agreement, or otherwise. It's got to be applicable. It's got to have certain prerequisites fulfilled. Otherwise, you can't conduct yourself except in a similar fashion as a transfer agent. And that is the presumption you need to break, because that's what's presumed. You're performing the same functions while in the public by signing official documents. You're performing the functions of public office. Don't know what else to tell you. That simple. Statement of and settlement for service charges. A monthly statement of service charges is provided to each account holder by the 7th business day after the end of each month. Service fees are computed on a calendar month basis and are charged on the 15th day of the following month or the next business day, appearing on the daily statement of account as FRB service charges. Federal Reserve Bank service charges. Charges are debited from an account holder's master account unless the financial institution designates a correspondent for settlement of such charges by executing a transaction and service fee settlement authorization form in the form of Appendix 2. And they've got that in the note down below. 12. Administrative Reserve Bank reserves the right to accelerate the debiting of Federal Reserve Bank service charges without notice to the account holder. That's one of the services, is a notice, and they're reserving the right not to give you notice. Okay? An account holder is responsible for verifying the information on each statement of service charges and must promptly notify its Administrative Reserve Bank in writing of any error on the monthly statement. You guys look at your monthly statement. Tell me if that's not in all caps. Tell me if it's not possibly the last name, comma, first. You know, any kind of difference like that. Even the legal name is not the same as the given and family name. Something was converted for a specific purpose. Has to be outlined. And that's the error. You were never taught and never able to qualify under 12 U.S.C. 611 through 614. If you had been taught, if you go back to the beginning, de novo, and had been taught, then you might be able to. But as it is now, it's beyond the point of qualification for most people, particularly myself. I'm 57 fucking years old. An account holder is responsible for verifying the information on each statement of service charges and must promptly notify its ARB in writing of any error on the monthly statement. So I'm giving you guys the information. You now have the knowing. You now have a duty to verify the information on the statement is in error. You now know the error, at least one of them. And that one error is cause enough for review of the entire record, because the record must reflect accurately. It is the integrity of the record. It is the enumeration of the record. That is why it's called integrity. It is integral. It means integers. If the account holder fails to provide written notice to its ARB of an error in the monthly statement of service charges within 2 calendar months from the day the statement of service charges is made available to the account holder, the account holder is deemed to have approved the service charges listed in the statement of service charges. It's deemed you have approved it. That's merely still a presumption. Again, back to the beginning, if I'd have known that before, now that I know better, I will, within 2 months, I will take care of those charges appropriately by act statement. Sorry, that was an error. Don't let it happen again. Here's the directive you're supposed to follow from now on. Accounting information services. An eligible financial institution may request certain intraday and end-of-day accounting information services, as well as other account or transaction inquiry and report generation services as offered by the reserve banks from time to time, such as Fed Transaction Analyzer Service, described in Appendix 4. Together, accounting information services. Operating Circular 5, electronic access, applies to accounting information services accessed by electronic connection. This is your phone, folks. This is one of the services that they have to provide through those electronic devices. That's why they create all them apps, so that you can use this part of the service agreement. It's an authorization so that they can use that device to route things. Credit card. Credit card means any card, plate, or device used to obtain money, property, labor, or services on credit. From time to time, such as the transaction, operating circular, where did we leave off? Accounting information services accessed by electronic connection. Charges set forth in Reserve Bank fee schedules may apply to certain accounting information services. That's why when you go to the ATM, that's an electronic accounting service. And some of them, as private vendors, may charge you a surcharge for using them, because that surcharge is because they're using a different surname than the patronymical corporate entity as a public institution, a bank. They're doing it privately as a commercial vendor of the machine itself, which is merely a routing access point, a device. Accounting information provided by a reserve bank may not be timely as a result of reserve bank processing or transmission delays. If a financial institution or its agent determines that it has received information through accounting information services that is not intended for that institution, the financial institution should immediately notify its ARB. So now that you know that there's an error in that bank account that you are an account holder of, I don't know what your excuse is not to go close it, other than being afraid of not being able to conduct your own banking affairs, or at least do your research so you can learn how to. It's important to understand how this stuff is structured, and that when you get involved in those opening an account, those agreements are converting your rights, titles, and interests to the legal name and its use. That's what the correspondent, respondent, ARB, FRB, it's all a chain of title where everybody else gets to use that rights, titles, and interests, or rights, titles, and rights, interests, and titles of that name for their own benefit. And it's not until you learn how to use it for your own benefit that you keep them from doing so. And they can only, under directive, do certain transfers that you direct. No one else, once it's all set up with your own private trust and everything, they can't do any public administration. This is, again, Scott versus McNeil. A court of probate has no jurisdiction over the estate of a person who is in fact alive. And that's all they're doing, is they're probating estates, because you have no living will. It's not stated as a living trust, pure and simple. Let's see here. So it's specifically telling you, you have to give them notice of the error, and you have to let them know what the error is. Once that error is known, it's a requirement to go through the entire record and fix all such errors and any others that are discovered. It's called discovery. They literally tell you it's called discovery in those administrative courts. Overdrafts. Overdraft policy. An overdraft occurs when a master account has a negative balance at any time during a business day, daylight overdraft, or at the end of a business day, overnight overdraft. An account holder does not have a right to incur an overnight overdraft in its account. It says an account holder does not have a right to incur an overnight overdraft in its account. An account holder may incur daylight overdrafts in its account only to the extent permitted by its ARB. So you have to make certain agreements. And we even see certain banks do allow for overnight overdraft forgiveness. Collection of overdrafts. Noticing that it's a debt. So what happens is if you go into an overdraft, they're telling you that you're creating another debt based upon a debt that's already there. How is that possible? Because somewhere, someone along the line claims to have had to have covered your debt. I want to ask everybody, knowing this, and knowing how many people have had bank accounts where you've overdrafted, we all know about the credit score. What about the debit score? Wouldn't the debit score account for things like that? Why isn't there an equalization of what a credit score is versus a debt score? Oops. See, if the United States is known as the debtor and it's located in Washington, D.C., and you're the one with the credit score, shouldn't that tell you something? An overdraft is due and payable immediately without the need for a demand by the Reserve Bank at the earliest of the following times. At the end of the funds transfer business day for purposes of FedWire transactions. See Operating Circular 6, funds transfers through the FedWire Funds Service. At the time the Reserve Bank, in its sole discretion, deems itself insecure and gives notice to the account holder, or at the time the account holder suspends payments or is closed. At the time the account holder suspends payments or is closed. An overdraft occurs when a master account has a negative balance. How, under collection of overdrafts, if an account holder suspends payments or closes the account, is that an overdraft? This says at the end of the funds, or an overdraft is due and payable immediately. This is ambiguous and says at the time and the account holder suspends payments or is closed. I would question that one. Or as you see, I am questioning that one. That language does not make sense. The account holder is responsible for having in its account, at the time the overdraft is due and payable, a balance of actually and finally collected funds sufficient to cover the aggregate amount of all of its obligations to the Reserve Bank. I want to point out again that that's 12 U.S.C. 611 through 614, where you have to have a communication with the Federal Reserve System, Federal Reserve Board of Governors, to establish your financial institution through proper documentation and notifications and qualifications. And if you haven't done that, then it's not done yet. And if you can't, and you find some reason that you cannot qualify, then it becomes impossible, and therefore they have to recognize a different value. Remember 18 U.S.C. 8, obligations and other securities in the United States. And in there, in plain writing, lowercase, after one comma, it says stamps and other representatives of value. So you have to be allowed a representative of value. This is today's negotiable instruments. They have to allow you to negotiate. Remember, for money, property, labor, or services on credit, not with money. Remember, it's money, property, labor, or services on credit. Security interest. To secure any overdraft in the master account, as well as any other obligation of the account holder, whether now existing or arising in the future, owed to any reserve bank, the account holder transfers and assigns to each reserve bank maintaining a master account for the account holder, and grants to such reserve bank for itself and to the extent permitted by law as agent for each other reserve bank, to which an obligation is or becomes owing, a continuing security interest in and lien on all the account holder's right, title, and interest in property, whether now owned or hereafter acquired, in the possession or control of, or maintained with any reserve bank, including but not limited to any account or deposit of the account holder that is maintained with any reserve bank. It's items in the process of collection of their proceeds and any investment property, including securities, security entitlements, and securities accounts, but excluding any investment property in any unrestricted securities account, as such term is defined in the Reserve Bank's Operating Circular Number 7. That the account holder may not encumber under applicable law. That the whole account holder may not encumber under applicable law. So when you open those accounts, they're telling you you're handing over your rights, titles, and interest in property. They're not specifying any property. They're just saying your rights, titles, and interest in property. So when the state claims that the title is held in the state, it's actually held through the Federal Reserve System, through that kind of documentation. And it starts out again, folks, with the SS5, wherein on the front they give you a Social Security number, which is used for placing liability on the public record. And the one on the back has the Federal Reserve routing number on it. Routing transit number. The security interest granted by the account holder in this section 5.3 is in addition to and is to be construed to be consistent with any other security interest granted to any reserve bank by the account holder under regulation or agreement, thus the SS5 agreement. That is Federal Reserve proprietary information known as a Federal Reserve routing transit number. Upon the occurrence of and at any time during the continuance of an event of default, remember what we read last night? Incident means an event or series of events that causes a reserve bank to determine that misuse of sensitive consumer information has occurred or is reasonably possible. And you're the one that's been entering in the errors because you are not reasonably able to comprehend this stuff unless you have been learned in it. However, now that you know some certain distinct elements that say it is not correct at this point, it's time to start doing some attempt at correcting. If it is possible, then you can move forward. If it is not, then you have to construct a new remedy. Upon the occurrence of and at any time during the continuance of an event of default, any reserve bank may take any action authorized by law to recover the amount of an overdraft or other obligation. This may include the exercise of set-off without demand or notice, the realization on any available collateral. That right there, folks, is a very important term to remember. You have the right to realization on collateral. Well, let me see here. The exercise of notice, the realization on any available collateral and any rights, titles, and interests. It says this may include the exercise of set-off without demand or notice, the realization on any available collateral, and any rights such reserve bank may have as a creditor under applicable law. See, and that's what they're doing. They're claiming the rights as creditor. When you do that, they are claiming the right as creditor. You're the account holder, and you're holding an account of a creditor. They're claiming that creditor. They transfer, you voluntarily transfer your rights, titles, and interests in property, and one of those properties is that very account, and the other properties are your intellectual properties, the data elements that you gave them for their use of the rights, titles, and interests in that intellectual property. It's basically saying that they are taking the rights of your creation. It's a transfer of copyright interests, which comes into play, folks. Let's go on to the next part. Reserve Bank 6.0, Reserve Bank Response Program. Remember, we have a respondent and a correspondent. Okay. Reserve Bank Response Program for unauthorized access to sensitive consumer information obtained in the course of providing financial services. Remember, folks, the Social Security number is not required for any such accounts, yet they ask you for that Social Security number. What's that tell you? There's already a master account set up, folks. It's already there. All the elements are already there. They already know you already know what the Social Security number is, and I've told you many times. that they convert the last name to a firm name, the first four letters of the last name in all uppercase, and they convert the Social Security number by removing the dashes, creating an obligor number. The obligor is the one that's liable for the payment. And if it's identified by a number, then what is the importance of that number? It's part of the routing transit numbering system. They're all different numbers that are used for different direct routes. You just have to learn how to direct it for which route. The Reserve Bank's possession and use of consumer information. Like I told you, it's a usufruct system. You're supposed to have possession and use of your information, but when you give it to them, in so doing, you are transferring, as it said earlier, your rights, titles, and interests in property. That includes the very property of the information that you just gave them. The reserve banks do not hold accounts for individuals and do not provide reserve bank services to individuals. The administrative reserve banks provide administrative services to individuals. In case you don't understand being organized under the laws of the United States and not being organized under the laws of the United States, and therefore needing to be administrated. The presumption. In the course of providing financial services to financial institutions and their authorized users of financial services, the reserve banks obtain, store, and transmit information that includes sensitive consumer information. Under the general supervision of the Board of Governors, the reserve banks have implemented, remember, contract terms and conditions required to implement statutes or executive orders, commercial items, commercial services. This is a contract form right before you. This is an offering. They're telling you what the conditions in the contract are. They're telling you if you open an account and become an account holder of a administrative reserve bank, you will, in that signing, hand over your rights, titles, and interest in property. You have to be able to make the amendments so that they benefit you. You do not sign over those interests. Have implemented information security measures designed to protect the security and confidentiality of sensitive consumer information, to protect against any anticipated threats or hazards to the security or integrity of such information. Again, you entered the information in error. It is not correct. It doesn't have integrity. It's not supposed to be there. It's not supposed to be enumerated. It's not supposed to be integral to that record. Only relative. And to protect against unauthorized access to or use or reuse, such as insurance and reinsurance, surety and resurety, by swapping your insurance credit defaults. Such information that could result in substantial harm or inconvenience to a consumer. Listen, buddy, if you lock me up, I cannot provide the proper maintenance of the account, and therefore it's a default of your account that I am an account holder. You have to learn how to put it back on and let them know that it's detrimental to them. More severely than it's detrimental to you. Yeah, sure, you'll be able to put me in jail or something, but if you put me in jail or whatever, or kind of try to place some kind of sanction against me, what about the supposed cooperative agreement that is implied in the very contract that says it's negotiable and arbitrary, meaning that we're supposed to sustain a state of agreement and negotiation. Why the controversy? This is part of the problem. People don't comprehend your ability to negotiate, and that's based on the knowledge. That's the true benefit, folks. That's what gives you the ability to do this kind of stuff with experience, repeatedly gaining more and more wisdom, which leads to a greater truth. As part of their information security programs, the reserve banks have created a risk-based program. That's what I was just speaking of. It's insurance. It's an insurance scheme. Banks are required to carry insurance because it's a risk-based program to address incidents of unauthorized access, which means it's a default to sensitive consumer information. So even if it's your own fault, it still acts as a default. Don't you get it? Use it to your advantage. That takes into account the size and complexity of the reserve banks and the nature and scope of the reserve bank's activities. This section 6 is an integral part of the reserve bank's response program. Again, the respondent, and as a account holder, you are allowed to act as a co-respondent for the respondent, saying that you are a reserve bank agent. Still a presumption until it's fully qualified. If you can't be qualified, it's an impossibility, and the record must be restricted. It must be sanctioned. It must be redacted. It must be declassified. Whatever you deem necessary to make it correct in its reflection. Instant response by the Reserve Bank. Suspected incident. Suspected. Somebody has to have viewed it. Somebody has to have seen it to make it observable to someone else. Suspected incident. If a reserve bank has reason to believe that an incident might have occurred, the reserve bank will promptly investigate to determine whether, in the judgment of the reserve bank, an incident has in fact occurred. The incident, folks. The incident. SS5. Mom's enumeration at birth, allowing for the establishment of the assignment of a Social Security number known as a taxpayer identification number to a legal name, which is a translation of the given name and a family name, one being a legacy, one being an inheritance. The two become one, a legal name. It's all rebuttable. Every last bit of it. Again, de novo, back at the beginning. Snafugo walks into a bank. Suspected incident. Yes, yes. Inside joke for most. All right, so let's get back to it. Got a little bit more to go here. Confirmed incident. What do you see in there, folks? Do you see the term firm? Confirmed incident. See, you're the one that put the information on the record, so therefore it is a confirmed incident if you know what the suspected incident is. Get it? If the Reserve Bank determines that an incident has occurred, the Reserve Bank will notify the Board of Governors as soon as possible, assess the nature and scope of the incident to identify what sensitive consumer information has or might be misused. So when my companion has served this country for 35 fucking years in the government as a special education teacher in the public education program and has her own retirement account and is in fact retired and has never been of the military because she is in fact, quote, female, a woman as such defined, Somebody is making errors as we're trying to correct the record. Somebody keeps trying to take money out of her account. See, somebody else is authorizing as a correspondent to the respondent to settle for the respondent in the correspondent capacity. And they're not actually the correspondent. They're just another, what do they call them? Oh, another brain fart. Anyway, thief. We'll call them thief for now. There's a much better term for it, but these credit collection companies that buy and sell everybody's debt claim to be the creditor. That's exactly what's happening here. They're claiming as a correspondent to the respondent, who is supposedly the creditor, and taking care of rights, duties, principles, and obligations for their rights, titles, and interests that you signed over. You don't have the rights, titles, and interest in property, so you don't have the rights, titles, and interest to stand up and fend for it. That's why there has to be a correction. That's the only way to do it. Take appropriate steps to contain and control the incident while preserving records and other evidence. Does that sound like an injunction? Close to it, kind of like verbiage. Follow the notification procedures set forth in 6.2c, unless requested by an appropriate law enforcement agency to delay providing such notice. Reserve Bank notification to financial institution of confirmed incident. If the Reserve Bank determines that an incident has occurred, the Reserve Bank will take the following actions for the purpose of facilitating notice to consumers whose sensitive consumer information has been or might be misused as a result of the incident. If the incident involves sensitive consumer information identified with a consumer of a particular financial institution, of a discrete group of financial institutions, the Reserve Bank will provide notice of the incident to each of the identified financial institutions, which shall include a description of the incident in general terms. The type of sensitive consumer information that was misused, in this case, my companion's case, they're using identifiable information as if though she's allowed to invest as a firm and provide an obligor number for said obligations when she is retired. Again, she fulfilled her obligations as the record already reflects, but everybody's ignoring it. They're refusing to remove the probated estate from their commercial jurisdictional venues now that she's retired and no longer an officer of the public trust. Has been or might be misused as a result of the incident. The incident is the false collection of a false debt that she is no longer obligated for, as she has been discharged of her duties, is resigned, and retired. If they refuse to allow her to settle the estate, it's evidence of malfeasance of trust. If the incident involves sensitive consumer information identified with a consumer of a particular financial institution or discrete group of financial institutions, the Reserve Bank will provide notice to the incident or of the incident to each of the identified financial institutions, which shall include a description of the incident in general terms, the type of sensitive consumer information. The type. Again, this goes to the language and the fact that she's no longer under contract. She's no longer subject to the contractual grammar of those terms. She no longer falls under the organized under the laws of the United States, as now she's fulfilled those obligations. Pure and simple. She's now a single single member entity. She no longer qualifies for immunity unless it be foreign sovereign immunities. She no longer has the capability of hiring an attorney for lack of a board of governors or board of directors, and therefore she must, as a single member entity, do the directing herself. Pure and simple. The type of sensitive consumer information that was misused or the subject of possible misuse, and general description of what the Reserve Bank has done to protect the sensitive consumer information from further unauthorized access. And I'm going to drop over to another one here real quick. Let me pull it up. Okay. This here, make sure it's up there, make sure we're still going. All right. SR 20-23. This is the supervision and regulation letters of the Federal Reserve, the Central Bank of the United States, provides the nation with a safe, flexible, and stable monetary and financial system. Here it says, SR 20-23, interagency order, granting an exemption from customer identification program requirements for loans extended by banks and their subsidiaries to all customers to facilitate purchase of property and casualty insurance policies. First of all, I want to point out that this is in regards to the, where is it? Talks about the FBA's, FinCEN, and all that, CIP, Customer Identification Program, National Credit Union, where is it? USA Patriot Act. The CIP rules set forth in Section 326 of the USA Patriot Act requires a bank to implement a CIP that includes risk-based verification procedures that enable the bank to form a reasonable belief regarding the identity of each customer, including, at a minimum, obtaining the customer's name, date of birth, address, and tax identification number, and to establish risk-based procedures to verify the identity of new customers. To verify the identity of new customers, isn't that what the enumeration at birth does? And then when you turn 18, SS5, you fill it out, sign it, and have it notarized and send in, and lo and behold, here you are, you verified it. But again, it's a false entry. You weren't supposed to enter under that kind of situation. You're still in development stages. You haven't qualified through 12 U.S.C. 611 through 614, where you've had the communications with the Federal Reserve and the Board of Governors, providing for a charter and a board of directors and obligations and security investment and all that. You haven't done any of that. So therefore, it's not actual. It hasn't been actualized. It hasn't been realized. Remember what we spoke of earlier, realization? So the next one, endeavor, as we were talking about, it hasn't been realized, but there's an endeavor to realize it, to provide each affected financial institution with the information the financial institution needs to identify its customers whose sensitive consumer information might have been misused as a result of the incident, but only to the extent the Reserve Bank is reasonably able to identify, retrieve, and deliver such information. Again, they're able to do so through that SS5. That's where the original Reserve Bank routing number is established on the back of that card. That is such an account. And cooperate in the financial institution's efforts to identify and provide notice to affected consumers of the financial institution. If the Reserve Bank is unable to associate the incident with sensitive consumer information related to the consumers of a particular financial institution or discrete group of financial institutions, the Reserve Bank may take whatever actions it deems appropriate to provide notice of the incident to affected consumers, including providing notice to every financial institution. In other words, if there becomes a strike on your name and they can't identify it for some reason, and this is why it's important to know what you're doing before you go start telling people to file this document or this document or this document, there's certain information routes that you have to maintain or obtain in a literal pattern. It has to be a certain process. And if you don't, you could fuck certain things up, and trying to go back and fix them, you may not be able to do. This is a particular situation with the numinant. You have to be able to get you get the decedent numinant first, which is by filling out a certain form, and then you request, after you get that, the live numinant, and that has to be done by handwritten request to a different office. So it's a process in all ways, and if you don't do it in that manner, they might close certain accounts that you can't turn around and get back into. So it's a very delicate thing. That's why I don't go throwing things at the wall anymore. And I don't suggest you do it either. Again, don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do research so you know. A Reserve Bank may take any actions in addition to those set forth in this section 6.2c that the Reserve Bank deems necessary. Obligations of a financial institution that receives notice of an incident from a Reserve Bank. A financial institution that receives notice of an incident from a Reserve Bank under 6.2ci must notify its affected consumers unless the financial institution, based on information not available to the Reserve Bank, reasonably believes that the incident does not create a reasonable possibility of misuse of sensitive consumer information. And this, again, folks, is so imperative why you need to understand what the error is and that it's you making it so that you can express that to them and relieve them and absolve them and lead them not into temptation and deliver them from evil. This is a matter of repentance and forgiveness, and it's supposed to be inherent within the system. Their entire set of laws is based on Scripture and the processes therein, including the administrative process expressed in Matthew 18, verses 15 through 20. The financial institution will provide the Reserve Bank with any requested information relating to 1. What actions the financial institution has taken or plans to take in order to notify its affected consumers pursuant to this subsection, and 2. The basis for any determination by the financial institution that the incident does not create a reasonable possibility of misuse. Should be of sensitive consumer information. And here we're using the same premise, but we're giving them notice as a financial institution, a consumer that has been misidentified as said financial institution and not qualified to be giving that sensitive consumer information. See, again, if we are a buyer or a seller, either one, as a consumer, we're obviously a buyer, we're allowed to give a number in lieu of a name and address, a widely recognized, commercially identifiable number. That's those numbers on that Social Security card. You already have it. It's already been done. The notice from the financial institution to its consumers must be made in a manner reasonably calculated to provide actual notice of the incident to affected consumers and must contain an accurate description of the incident. You have to be able to describe them why you're not qualified to be giving them a name and address with all that other stuff and signing the documents. Because you're allowed to give a number in lieu of a name and address. And if you're allowed to give a number in lieu of a name and address, folks, I want to ask you seriously through reason and logic. If you're allowed to give a number in lieu of a name and address, and that's in lieu of the name, then why would you turn around and sign a name when you already gave a number in lieu of that name? It doesn't say that you're then required to give a signature. It says that you're allowed to give a number in lieu of the name and address. And if there's a customer identification program, an exemption program, where you can qualify that the identification is already there and affirmed and confirmed, but it's been misused and needs to be corrected so it can be used appropriately so that the funds go directly to where they're intended, then there's a serious problem. People aren't acting in good faith. And again, if you knew this and knew that every time you sign one of those documents without knowing how to direct those payments or credits, then you're actually creating a greater debt on the United States. You're supposed to be not, and when they say allegiance, it's not that you pay homage to them or anything, but you have an equal station. You're in allegiance. You're in alliance. You have a co-mission and a co-vision. You have the same vision, the same mission. And it's meant in peace, not war. Again, all contracts have an implied peace treaty supporting them in the ultimate international venue. Ultimate Naval Treaty of Peace. Okay, the type of sensitive consumer information at issue and steps taken by the Reserve Bank to protect the sensitive consumer information from further misuse based on the information provided by the Reserve Bank and include any other information that the financial institution provides when its own sensitive consumer information has been compromised with promise. Somebody else has used your name as a promise, and they've done so without your consent. Your handwritten notice of consent to promise to pay a debt, to communicate about the conveyance of a debt, to communicate about the conveyance of a promise. That's what you're doing. You're communicating the conveyance of a promise of a false debt. Receipt of unintended sensitive consumer information by a financial institution. If the financial institution or its agent receives sensitive consumer information that is not intended for receipt by the financial institution must immediately notify the financial institution's ARB. So all you got to do is give them notice yourself when you go to close these accounts. And again, this is something that I'm telling you to do. It's not legal advice. It's not financial advice. It's just the way my opinion is set forth through my research that this is what we're supposed to do. And that is, we are not supposed to be dealing with these public accounts through these Federal Reserve banks, as that's a reserve currency. We are supposed to be able to have our own assets in a cooperative agreement with an offshore bank account. In other words, a foreign bank, a foreign a foreign country money judgments recognition. Again, that stamps and other representatives of value. This isn't the only representative of value, and it's certainly not the only system with its own representative value. Matter of fact, there's different representatives of value, and then all of a sudden come along other different representatives of value. That's how this whole system has evolved, and that's why we have a new representative system of value or system of representation of value, the bitcoins, the blockchaining, the ethereal coins, the electronic value system. Imagine that. It's all merging, converting, and changing before our eyes. And if you don't learn how to adapt, you're going to get caught behind, folks. Costs. The Reserve Bank that triggers a financial institution's obligations under Section 6.2D will reimburse such financial institution for an appropriate allocation of the financial institution's reasonable costs of providing notice to its consumers under that Section 6.2D. The Reserve Bank of the financial institution shall negotiate in good faith to determine such allegation. Again, you see here, folks, it is a matter of negotiating. It is a negotiable instrument, and they must and are regulated to do so. Make sure you learn how to redeem. That's your true negotiation, redemption, buying back. They talk about payment and repayment. Think about it. The next one, general duty of care. Unless otherwise specifically provided in another Reserve Bank operating circular, a Reserve Bank shall be liable only to an account holder. A Reserve Bank shall be liable only to an account holder and only for actual damages. So you have to have the realization, like I said, the actualization, the actual damages, the realization of damages incurred by the account holder. This is material fact evidence in the records. This is why you have to correct them. Those errors will come about and show themselves. Every deposit was a foreign deposit, and you recognize that in those foreign deposits, you handed all your property rights, titles, and interest in that property to the bank. And if you'd have known that, you'd never done it. Intent. Knowing intent. Had you known that, you would have never handed all your rights, titles, and interest in property over to these thieves. And proximately caused. What is the nature and cause? And proximately caused by the Reserve Bank's lack of good faith and failure to exercise ordinary care. Again, if the Federal Reserve knows that under 12 U.S.C. 611 through 614, you must be organized under those codes in order to open a bank as a master account, as an account holder, a correspondent, respondent, administrative reserve bank, or any other. Again, 12 U.S.C. 411, you're being presumed by your own conduct to be performing the functions of public office as an officer of a bank. And you keep telling them everything that is none of their business. You're a goddamn teller. You act just like it. You tell them everything they want to know. And in so doing, you sign a document, you hand over your rights, titles, and interest in property, just like it says. You read it right along with me, folks. A reserve bank is not liable for lost profits, claims by third parties, or consequential or incidental damages, even if the reserve bank has been informed of the possibility of such damages. Reliance on authorizations. A reserve bank may rely on instructions and authorizations purporting to be issued by an authorized individual. Remember, that's that individual that is authorized by the Social Security Administration when you sign up for SS5 at age 18. Employment. Records maintained on individuals. 5 USC 552A. That's employment, folks. And you use it to go out and get a job, an identification, or a driver's license, and a bank account. Or to continue on with a bank loan or a student loan to get a house or property or go to school. Great job. Great job. We're all enslaving our future generations by not knowing this stuff, folks. A reserve bank may rely on instructions and authorizations purporting to be issued by an authorized individual. So, as being the authorized individual, the reserve bank may rely on instructions and authorizations. So now it's time to learn how to give the directive because they are saying that they may rely on them. And all you got to do is show them the what I call a fortiori. It means the greater truth. Hey, I'm sorry, I made errors. That's the greater truth. It's not you guys' error. I'm the one that did everything wrong. So yeah, truly, the only liability here is the return of the rights, titles, and interest in property that I accidentally, through continuous and repeated exposure to the same conditions that placed a public liability on the record when I never expected nor intended. Oh, and by the way, I was the insured one. That was the intent of filing SS5, is for retirement insurance. Remember? The credits were already established, people. I've been paying in through the employment system every time I got a paycheck, and they took out the SSI and the FICA. Again, that was deposited in the state account, and it's known as insurance credits. Holder or respondent, whether by written or electronic means that the Reserve Bank reasonably believes to be authorized by the account holder or respondent, and may continue to rely on such instructions or authorizations until they are revoked by the account holder or respondent. For the avoidance of doubt, to the extent any provision in Article 4A requires agreements, other documents, or signatures to be in writing, a reserve bank may accept such documents as signatures in electronic form. This is where you can give them notice in private of the identification for that customer identification exemption program. This is by showing them a greater account or the establishment of an account already, and that would be that SS5. And again, that's merely in the situation here where we're opening a pass-through account, would be to settle such an account that was already established. That's all we're doing. In this correction of errors, giving a directive to open another account as a pass-through so that we can transfer the title with expenses incidental to the agency and then transfer it again once that's settled. Gathering up all the records, employment records, medical records, driver's license, ID, bank records, all of it, tax records, getting all that gathered up at the state level, and then title transfer expenses incidental to transfer of title to the United States, so we can do the settlement and clearing through the Federal Reserve banks, because that's where the clearance is supposed to be, or settlement's supposed to be done, is in the master account. And then once that's all settled, it's a release of the remainder credits in reversion back to the principal in the merger with a new name. And that's a transfer of title incidental expenses incidental to the Postal Service. That's that enterprise payment system account. At least that's my opinion. That's the way I see it working for me. That's the steps I'm taking. And I'll inform people as I go along. I'm getting ready to, like I said, I'm getting ready to do some moves as it relates to the statement of live birth, the birth certificate, DBA, and all that. So we'll see how it goes. And like I said, I'll keep everybody updated. By executing or submitting a form with pre-filled information, the financial institution represents and warrants that it has reviewed such information to confirm it is accurate as of the date an authorized individual signs the form, if applicable, and the financial institution submits the form. The financial institution agrees not to execute or submit a document which contains inaccurate information. You've been doing this all your life, folks. You've been giving them inaccurate information. It's time to stand up and correct it. You are not a Federal Reserve agent. You are not a resident. You are not a United States citizen. You are not a public officer. You cannot fulfill the capacity of a defendant or plaintiff in those administrative courts. The Administrative Reserve Bank, of which you are an account holder, or any respondent or correspondent thereof, you have made a mistake in realizing now that when you open said account, you transfer your rights, titles, and interests in property. Had you known that, reasonably and logically expected, no one would do that. And therefore, it's a withdrawing. It's a de novo, go back to the beginning. And if I can do it in good faith and full credit, I will do it. If not, it has to be withdrawn, and a new payment redemption has, or a new remedy has to be created. Yes, Rule House H6 is clearing and settling. That's for Canada. I can't remember what they call it down here, but I think it's something to do with Public Law 96 something. I'll have to get with Norman on that. But basically, like it's already done. There's already a clearance and settlement process. It's just a matter of directing it for that, rather than doing any kind of continuing on with releases. Like I said in the circular, settlement. Do the settlement. Direct the settlement. That's all you got to do. So, back to it. The Reserve Bank, excuse me, the Reserve Banks may use a third-party verification service to verify the identity of any individual authorized to act on behalf of a financial institution. Again, this is where you have to step up and correct the errors in the record and give them the information that you are the third party that verifies, because you're the only one that document can actually extend from. You are its very creation. Okay? That account, Keith Orland Little, doesn't come from Bob Smith. It comes from Keith, right here. Get it? Make the connection. Connect the dots. If applicable, the financial institution shall endeavor to ensure its personnel cooperate. Remember, we spoke the other night on cooperative trust, cooperative agreement. And we talked about mission statement, the things that we are doing, and the vision, the things that we endeavor to accomplish, to ensure its personnel cooperate with and provide current and accurate information to such third-party verification services. Quid quo pro, I provide you the verification service that you need for the services you supposedly are providing me. But now it's got to be done under a trust account, not a consumer account. A pass-through accounting. Because that's all you get to do now is the accounting. And it's going to pass through you. Somebody else is going to have the directive to receive or execute or transfer, things such as that. Again, this is the importance of your private documents and having your property in escrow through a collateral statement. The Reserve Banks may rely on identity verification received through such third-party verification service. And again, You're the only one that can actually truly verify yourself. Put yourself at the top of the chain. Disclosure of information, all the information, including but not limited to all transaction record and related information. You are relative. You are not a party to. You are relative. Obtained by any reserve bank while providing financial services under any operating circular may be used or disclosed by any reserve bank. You gave them the rights, titles, and interest in that property in its sole discretion for monetary policy, research, supervision, regulation, financial services, or any other purpose related to a reserve bank's authority. And again, I want to reiterate, this is for a reserve currency and not a national currency. Understand that? Institutions using financial services hereby consent to such use and or disclosure to the full extent permitted by applicable law. Feedback. If a financial institution provides a reserve bank with feedback, including but not limited to ideas, comments, or suggestions relating to the financial services, all intellectual property rights in such feedback and anything created as a result of that feedback, including new material enhancements, modifications, or derivative works, are owned by the Reserve Bank. You have to rescind those contracts, folks. Governing law. This goes against the your copyright transfer. See, they don't have a right. He who creates controls. He controls that which he creates. He that did not create cannot control. This is all violation of the actual creation mechanism that we were speaking about. That's why it's so important to understand the documents you're signing. Governing law and actions. This circular shall be governed by federal law and, to the extent not inconsistent with federal law, by the laws of the state of the head office of the applicable Reserve Bank, and federal law is where you have equity. It's the federal law that gives you access to the Supreme Court of the United States, which is the only court that provides for equity. Period. State courts are all administrative courts of law. By the laws of the state of the head office of the applicable Reserve Bank, any action against a reserve bank for any act or omission relating to an account relationship or transaction contemplated by this circular must be brought within 1 calendar year from the date of the transaction in United States District Court. United States District Court. By the laws of the state, United States District Court. I'm telling you, folks, we're supposed to go to the United States District Court, not the state courts, where the head office of the applicable Reserve Bank is located. Notwithstanding the foregoing, if the action relates to activity contemplated by another operating circular, such action must be brought within the time and in the United States District Court specified in that operating circular, if any. Right to amend. The reserve banks reserve the right to amend this circular and its appendices at any time without prior notice. Again, effective September 1st, 2023. So, folks, there you have it. Federal Reserve Operating Circular number 1 telling you that when you open these accounts as an account holder, you're signing over your rights, titles, interest in property. That includes the intellectual property, which is the data elements that you're giving them. So it's very imperative that you understand this and do your research. Again, don't believe me, don't believe the neighbor, don't believe the government, for crying out loud, don't believe your mother. So that you can learn how to do your own banking, because that's literally what you're going to have to do. You have to learn how to become banks so that you can operate together with other people as a banking system, not as a standalone bank. That's the whole premise, is mergers. So you don't stand as standalone banks. You perform a credit union because you're truly lending under the nation. That's what they operate on, is credits. You have to lend them credits, not money. The money don't mean nothing in the electronic system. They need credits in that electronic system. Better get modern. You better get up with the technology, folks. It is the new monetary system, but it's based on credits, the merits, the spiritual credits. And you have before you, like I said, a heroic imagination project where you get to project your imagination of your very own hero, which has the spiritual credence. Period. Well, that's about it, folks. With that, I'm done for tonight. So remember, I love you, but I don't give a rat's ass whether you love me back. So may God bless you and have a good night. Bye now.